there are state level trademarks and there are federal level trademarks. If it's a truthful statement and it's just a bad truthful statement, it's not defamation. If I don't like a gym because I quit because they tried to charge me a quitter's fee, and that's true, that's not defamation. If you lost one member and that was a loss of $500, like, yeah, that stings, but you're going to pay an attorney probably twice that to try to pursue a defamation claim for $500.
Hello, everyone, and welcome back to another episode of the Cheer Biz podcast. And I am here with our next episode with Matt Becker of gymlawyers.com, the man, the myth, the legend, attorney extraordinaire. He saves baby seals in the Arctic. Overall amazing human being.
Just you got to get in the water 3 minutes. You won't feel a thing. That's all.
Exactly.
It's just like a cold plunge.
Exactly. No, I was saying you save the baby seals, not you swim with the baby seals.
Oh, well, okay. I was just saying, like, you got to get in the water to save them sometimes.
Oh, true. You're like the baby seal lifeguard.
That's right.
You know, swimming out there, Baywatch style
on my
in
website.
the Arctic. Yes, I
save baby seals.
Today, we had an amazing interview last week. We have another episode set to come out from that one. So we've already released one, which if you haven't listened to it yet, we were discussing chargebacks. Really great conversation there. And we are going to be talking about some other stuff today. But before we get into that, so I don't steal your thunder, Matt, for the new listeners, who are you? What do you do? And how can you help their gyms?
Thanks, Dan. So, yeah, you picked up what I was throwing down last episode, huh? No, I'm kidding. So, I'm Matthew Becker. I'm the owner of Gym Lawyers P LLC. We are a legal consulting firm that focuses solely on helping gyms across the fitness industry make sure that they have all their legal questions answered, they're legally compliant, they have updated contracts, they're creating legal entities correctly, they're selling their gyms and buying gyms correctly within the law. Pretty much anything that impacts your gym legally, we either assist with it or we know somebody else who will assist with it. Helped gyms in cheerleading, gymnastics, parkour, pickleball, yoga, Pilates, CrossFit, personal training, online training, dance schools, you name it. And we've probably had a client in that area of quote unquote fitness.
Today, we're talking about the subject we're going to discuss is demand letters and or cease and desist letters, I believe. We're both. Yeah, both. Yeah, I definitely know what these are. As I alluded to on another episode, I may have recently gotten one of these, been the recipient. I don't send these out very much. And I definitely called Matt and I was like, tell me your thoughts. But why don't you break down what it is, what a cease and desist letter is, and what a demand letter is for the listeners?
Yeah, very similar, but from our perspective, they're quite different. So a cease and desist letter, we will get involved in a cease and desist letter in a couple of different areas, very broad-based. The primary time that we'll see a cease and desist letter come out is if there's some sort of a trademark. This is like the classic, I have a federal trademark on such and such name or such and such logo, and I think your gym is copying that logo or is too close to cause confusion in a consumer's mind, which is like sort of like the buzzwords. So therefore, because I have this trademark, I'm protected. I send you a cease and desist letter that says, you have X number of days to rebrand, stop using that color, stop using that logo, stop using that name, whatever it is, or else I'm going to sue you for a trademark violation. It happens. We can go down the route of the difficulty in enforcing something like that. But that's sort of like highbrow, number one time we'll see a cease and desist letter. Now, the two times that I've really seen it, primarily in like the cheer industry, is when a gym has like a really prominent all-star team or something like that. They have this logo, and maybe it's not even trademarked. They just really like their logo. And parents are going out, stealing that logo, say off their website or out of their parent handbooks or something like that, getting it screen printed on shirts or imprinted on backpacks or something like that. And then just using that logo and not paying the gym to buy their t-shirts, to buy their backpacks, to use the logo. So sometimes we'll get asked to send cease and desist letters to stop using the name and the logo without the gym's permission. The other time we'll see this a lot is with disgruntled parents. And when a parent gets really angry, and whether it's because their kid got kicked out of the gym, got kicked off the team, they got smacked with a quitter's fee, something like that, and they go on Facebook and they start talking crap about the gym owner or the gym or the coaches, or claiming people are on drugs, or all kinds of things. And so then we have to send a cease and desist letter to the individual that says, hey, stop saying what you're saying, or else we are going to have to take some sort of further action.
I've seen both of these quite a bit. I see them talked about a lot in terms of on various platforms and things like that, where people are like, oh, this parent is making, well, so we'll start with that one. This parent's making this shirt and it's got our logo on it and they can't do that. And I've seen people recommend, oh, well, go to your attorney and tell them that, you're going to sue them for trademark infringement. Can they do that?
If they have a trademark, there are two levels of trademarks typically. There are state level trademarks and there are federal level trademarks. So most people, when they say, I have a trademark, they mean federal, because most people are most familiar with a federal trademark. There's a whole process that you go through and you file it. And once it's filed and maintained properly, and it can be tricky to file them properly, but once filed and maintained properly, technically nobody else within the US can use that logo or that name. The other place that you can file it is at the state level. And then it's just like nobody else within the state can use that name or that logo or whatever you have as a trademark. But if you don't have a trademark filed, then you can't sue on anything there. You don't own, like you think, oh yeah, I own that name, I own that logo. And sure, you might, but it doesn't prevent somebody from copying you. So now let's assume for a second they are filed and you do have a trademark. You can sue somebody for basically what's called injunctive relief, which is a court's way of stopping somebody from doing something. But they're kind of dicey because, really in order to have a lot of teeth behind a trademark, in order to make it like really worth your time, you really have to show that like by them doing that, you are taking a massive financial blow, or there's a potential that you're going to take a massive financial blow. And the law doesn't like to operate a lot on speculation of like, if they're allowed to do this, continue to do this, I might see a loss of money. You almost have to go in and be able to show, look, people stopped buying my stuff because they were buying their stuff because they stole my logo and started screen printing it on t-shirts. And now I've lost $20,000 in revenue. Okay, great. Let's go sue on a trademark. But just because a parent's producing a couple of $15 t-shirts, $20 t-shirts with your logo on it, within all honesty, probably the best thing to do is just go to that parent and have a conversation with them and say like, hey, you got to stop doing this. Or just get an attorney to send a letter that says, hey, stop doing this. But if they call your bluff, you're probably not going to do much about it.
Yeah. My personal recommendation from the gym owner perspective would be, have the conversation, because threatening your clients with lawsuits is not the best customer service. And although they're doing something that you don't like, and that maybe even is in your policies and procedures that says, hey, you can't do this, it's still not a good look. And worst case scenario, just remove them from your program and say, hey, you can't follow our rules. And so we're just going to part ways. That's where you have the most control, and you don't have to pay expensive attorney fees, and you don't have to go to court, and you don't have to get a bad taste in your mouth and be known as the gym that sues their parents for making a t-shirt. Now, one of the other things that I see come up a lot is not just trademark, although people use this term kind of ubiquitously to everything. But in cheerleading, and you may have learned this by now, is not only do we have gym names, but we also name all of our teams. And each of our teams has its own name. And sometimes even those teams will have their own little like their sayings or words. So like my junior three's word is slay. And so you'll see that there will be gyms that will say, you cannot use our logo or the team name fame or their team saying slay on any apparel. And they then kind of have the approach of like, okay, well, I've told them they can't do it, but can you just say, well, I have a trademark on this word?
So language gets copyrighted, logos, pictures, colors get trademarked. So you would have to get a copyright on that slogan, that slogan, that logo.
I like that word. It's a slogan.
That's my new one. Everybody take it. It's a slogan. It's the newest thing. The logo, the slogan, the buzzword, your catchphrase, whatever it is. And again, if you can't own words unless you put them together in unique combination and the federal government agrees with you that you can own these words. Otherwise, you can't own words. And putting it in a parent handbook that says, by signing this parent handbook, you're agreeing that you're not using any of these. You're not going to use these words. You're not going to use these logos. Sure, you've got a semblance of a contract, but if you're asking me to step into the position of the attorney defending the parent who receives the cease and desist letter from the gym or the lawsuit from the gym that says I used slay and put it on the back of a t-shirt and therefore I breached the gym's policies. First off, I'm going to say, show me your trademark, show me your copyright. Okay. Secondly, I'm just going to say, look, there's no consideration here. Legal consideration is sort of an interesting doctrine, an interesting concept, but there's no consideration. You show me where the parent received any benefit by agreeing not to use the word slay on the back of a t-shirt. And so you're going to have a real hard time showing that there's an actual legal contractual agreement there to not use these words that are going to give you any legal teeth at all to try to prevent somebody from doing this. Again, it's have conversations. Let me have conversation if you have to. If the parent still pushes back, but in the long run, it's you're probably just beating your head off a wall.
So the next one that I think is frequently brought up, and you kind of mentioned it. So I've been here on both perspectives, where you have someone who left your program under less than stellar circumstances. Maybe you removed them from the gym. We had a mom years ago. We went through this where we got 15 plus Google reviews that were all from fictional names and Yelp reviews from fictional names, alleging all sorts of awful stuff. And nothing like that crazy, but, using all the buzzwords, they're racist or they're this or they're that, or they're stealing money and things that are just patently false. But this person was removed for being very, very unkind to coaches and athletes and parents. And it was like, you're not a good fit. And then they went on a rampage. And that's even harder because this is all fake names, right? So it's not, but I've been in the position, or I've seen people who've been in the position where it's on Facebook, where their name is attached to it. And they're going on platforms and they're saying, don't go to XYZ gym because my daughter went there and they were bullies and they were mean and
the coaches are on drugs.
Yeah. The key buzzwords that you hear are like bullying, abusive, those things get thrown out a lot, which are really inflammatory words with oftentimes not a lot of actual fact behind it. And, a lot of people will say, okay, well, that's defamation, right? They're committing defamation, which if it's posted on Facebook, it's more libel, right? Because it's printed or it's typed. But what's the difference between defamation and libel? And what are the factors that have to exist for it to meet standard, the legal standard?
Yeah. So defamation is just sort of a general legal term. And there are two types of defamation. There's slander and libel. Slander is an oral defamatory statement, and libel is a written defamatory statement. So you hit the nail on the head there. Somebody goes on Facebook and they start writing a bunch of fake crap about the gym, or truthful crap, but that's an automatic defense to defamation. That's libel. Somebody calls you up on the phone and starts saying a bunch of crap about you. That's technically slander. Although I just walked myself into a legal conundrum there on the definition of defamation. So let me take that back. Someone
says something on this podcast about...
Yeah. There we go. Yeah. Somebody says something at a podcast or at a conference or something else that is bad about you. That's technically slander, but it has to meet the definition of defamation. So what is the definition of defamation? Well, it has to be a written or oral statement that is published to the public or to a third party that is proven to be false. Okay, so and causes damage. It has to be a statement, whether oral or written, and it has to go out to a third party. So, like, I can tell you that you're an awful, terrible, horrible person, and that I think you're on drugs and you run a horrible gym, which is not true at all. But if I'm just saying it to you, it's not defamation, right? It's just sticks and stones. Okay. It could rise to a level of harassment, but it's not defamation. If I go on this podcast and I start talking about, your consulting group or something company, like that, right? Yeah. Like anything like that. And I'm now publishing it to a bunch of third parties. If I go on Facebook, if I go on Instagram and I'm now publishing it to a bunch of third parties, now we've at least reached that element, okay, of defamation. So it has to be a statement, has to be made to a third party. And it has to be demonstrated as false. If it's a truthful statement and it's just a bad truthful statement, it's not defamation. If I don't like a gym because I quit because they tried to charge me a quitter's fee, and that's true, that's not defamation, right? That's just me being a PO'd parent. And I'm just going on Facebook and I'm expressing that because I don't think that's right. And that's in my power as a consumer because it's a truthful statement. If I go on and I start, like you said, saying they bullied my kid, they were mean, they were dangerous, all this other stuff, and there's no way, like the difficulty with that stuff is like there's no way of proving that. It's all subjective for the most part. Then there's some borderline stuff there of like, is that defamation?
Right. And that's where I think a lot of people people get confused. Is something can be mean and hurtful, but it's hard to prove that it isn't true. You may know it's not true, but how do you prove that? And is it all in the eyes of the person is it all through their perspective? So to say they bullied me, well, yes, there's technical definitions of bullying. I hear the words bullying and trauma and things like that thrown around constantly, and used just nonsensically sometimes, oh, they got my Starbucks order wrong. What trauma? It's not trauma. But people say that. And so, you can't get that. It's hard to get the scope versus if someone got online and said, we quit this gym. Their coaches were physically abusive, striking my child, doing all these, and you could prove this is provably false, made up. We have video, we have all these things that's never occurred. That then would potentially end. Even still, if it's untrue, you still have to prove that damages portion, which is, again, incredibly hard in the cheer industry, especially if it's like, if you were to say they made this post and the entire team quit the next day, probably could prove those damages, right? Like, I lost an entire team, I can prove that revenue. But to say, oh, well, I know people didn't join my gym, I lost future revenues. It's really hard to prove those future revenues were lost simply because of the statement, right?
Yeah, the statement has to damage your reputation in some way. There is an assumption here that in all of these various statements, they're naming the gym, because otherwise, who knows what they're talking about? But you have to demonstrate that it actually damaged your reputation. And the only way that we're going to be able to do that is to demonstrate some sort of loss of revenue, loss of potential revenue. Loss of potential revenue is really hard And again, it has to be something that's like worth pursuing in the legal realm. Like if you lost one member and that was a loss of $500, like, yeah, that stings, but you're going to pay an attorney probably twice that to try to pursue a defamation claim for $500. If you lost $10,000, okay, maybe that brings us over the threshold. If we can meet all of the other elements, that now it's actually worth pursuing something. But that cease and desist letter starts to come in an effort to try to get them to stop before there's actual damage that we can claim, or we can claim that we lost that reputation.
It's a complex web. So let's say you believe you have a case. Someone has gone online and they've lambasted me or my company. It is provably false. It has had a financial impact. Next steps are, if I really want to move forward, or what, I guess, if you were talking to an individual who's like, I'm ready, like I want to sue the person, what might be some things you would tell them, pros and cons of going down this path?
One of them is the biggest one is what we just talked about, which is I kind of threw out there unprompted, is just sort of that cost of benefit analysis of what does it look like to actually go to court over this? Again, do we think it crosses a threshold of basically monetary value in order to justify getting something wrapped up in court for a year, 2 years, 3 years? You have to deal with this constantly. You're going to have to pay attorney's fees constantly. You're going to be ripped out of your business to go deal with legal things. There's a lot that comes into play when you try to go over that threshold of, okay, now all of a sudden, like, I want to sue. And as attorneys, when we're litigating, we really have to be careful to like really suss out, like, are you doing this because we can actually demonstrate some sort of monetary value, or are we doing this out of principle? Because from an attorney's perspective, and this is sort of just to protect gym owners in general, from an attorney's perspective, a client that comes to you out of principle can both be the most lucrative and the most annoying client that you ever have. Because from an attorney's perspective, I know that I can just keep charging. I can keep doing all of this work, and at the end of the day, I'm going to send you a bill and you're going to pay it because based on principle, you have to have this person go down. And, for better or for worse, the attorneys know that. Okay, now the attorney is also going to know, well, yeah, and this client is probably going to be a pain in the butt because they're in it for principle and they are just damaged in some way that nothing is ever going to be able to fix. And, I have talked with attorneys in the past who have said point blank, when a client is coming to me based on principle, I automatically jump up my retainer fee because I know this client is going to be a pain in the butt and they're going to pay. So if you're a gym owner and you're thinking, I want to go through with this, I want to take that next step, and it's based on principle, just know that the attorney knows that. And for better or for worse, they're like, I don't want to go to the extent of saying like they're going to take advantage of that situation, but they know it's on principle. They know there's no money at the light at the end of the tunnel. And like, you have to accept that. But if the gym owner still says, that's fine, I still want to go through it, I'm damaged in X, Y, Z. Now we get to the point where the demand letter comes into play, Dan. And this is what the other type of letter we were talking about at the beginning of this episode. So cease and desists are really meant to try to prevent us from ever getting to litigation. Once the owner of a business, once the gym owner, once somebody reaches that threshold, if they're like, I'm going to do this, they're going to go to an attorney, they're going to hire an attorney, and the first thing that attorney is going to do is send a demand letter. A demand letter is basically saying, we believe that you've defamed the gym, we believe that you've caused $10,000 worth of damage, pay us our $10,000 right now and we'll go away. And then they send out that demand letter and they say, you have 14 days, you have 30 days, whatever it is. And if you don't, then we're going to file a lawsuit against you.
So what happens if you get a demand letter? What should you do?
Call an attorney immediately. Don't assume it's nothing. Don't call their bluff. call an attorney. You can call us, and we'll just sort of take and look at the demand letter, talk with you about your options, talk with you about sort of, is this just sort of a laughable thing? Are there any teeth here? Sometimes it just scares gym owners to the extent that the gym owner is going to say, look, I don't want to try to call a bluff. Can we throw a little bit of money their way and get them to settle this thing and go away, because I don't want to deal with it. They just get like instantly scared. And that's understandable. The legal system is a very scary thing. If you don't, I'm an attorney, and I still think, whenever I went into litigation, I still thought the legal system was a scary thing.
Yeah, it is. And I think that the scariest thing in these circumstances when you get these demand letters is, even if you're righteous, if it goes through the court system, there is an expense. Like, you're going to have to pay your attorneys all the way up and through whatever litigation occurs. And one of the things I was trying to maybe suss out or get at is, my understanding is in most lawsuits, there's going to be some sort of a countersuit in a lot of circumstances for attorney fees and things like that, to say, well, this is, harassment, et cetera. And so the most famous being, if you guys didn't keep track of it, the Johnny Depp trial for defamation. And that whole thing but there was lawsuits going every direction. Amber Heard was suing Johnny Depp. Johnny Depp was suing Amber. They were all suing each other. And the judgment ended, and they both owed each other money at the end. And so now, granted, she owed him a lot more, but still, like, they lost judgments both ways. And it's not just a simple black and white, you're right, they're wrong situation in the eyes of the law. You also could go through this entire process. They could win, and a judge could say, and I award you attorney fees. So now not only did you lose that process, but you now have to pay their attorney fees. So there's a number of drawbacks to going into that legal system. Like, it's just, yes, anyone can sue anyone for anything, but there are some concerns.
Yeah, and just understand that nothing in the law is black and white. We try to make things as black and white as we possibly can through contracts, through setting expectations. But once litigation doesn't happen because everybody agrees on something. Litigation doesn't happen because we can look at a contract and say, well, yeah, but it said you don't get a refund. And everybody goes, oh, yeah, you're right, I didn't get a refund. Okay. There's no litigation there. Litigation happens because nobody agrees. And it's not obvious. It's not black and white. Both sides think they have an argument. And that's why we end up in court.
So as we talk about defamation, because I think this one everyone understands the logo and trademark stuff, and you're going to deal with it if you're a gym owner. And like, honestly, I'm just going to give my 2 cents on that one again. Yes, it's annoying. Have it in your policies, have conversations with people. But at the end of the day, you should also be excited that people want to wear your brand and people want to promote your stuff. So like, there's a give and take. Like, yes, it's annoying. Yes, you still should have a conversation. I'm not saying let people go hog wild on making your apparel, but also know that's like a good sign, and just have a polite conversation with them and explain, hey, look, our margins are really tight. And this is one of the ways that we help pay our coaches and buy new mats and do these things by being able to sell stuff. So when you are a competitor to me, that's not great. So maybe would you ever want me to I'd be happy to contract you to make one of our specials, and I'll cut you in, right? Like, there's ways to do that and bring parents in and have them be a part of it and give it a try. But the defamation thing, why is defamation so hard to prove and prosecute? Because when people say things that hurt my feelings, I don't want them to say them anymore.
So wait, the question is like, why is it not just black and white though? Like,
yeah, why is it so complicated?
Well, because we have a free speech in this country, and court systems don't want to. They don't want to trample. I mean, my goodness, there are treatises written on the First Amendment and our free speech, and what qualifies and doesn't qualify as free speech, and how much the government can come in and trump our free speech. And, people love to stand on tops of mountains and plant their American flag and say, this is my free speech, right? And And then you and I can go back and forth about like, well, I'm not allowed to say X, Y, Z. Why is that not a violation of my free speech? And it's like, again, there's like volumes of picking the legal system, picking apart what is and isn't considered free speech.
Tomes of information.
Right. But at the end of the day, they start with the idea of we as a country have free speech and we don't want to prevent people from being able to express their free speech. And then we go, accept. And so defamation is hard because we're trying not to prevent people from expressing themselves, even if it's in a negative light.
I think that's I kind of knew the answer, but
I knew that. I appreciated that softball there, Dan. Thank you.
Well, I think it's important to touch on because in the legal system, right, everything falls back to the Constitution in a lot of ways. Like there can't be a law that then violates the Constitution and infringes on people's constitutional rights. And so when these laws are crafted, these defamation laws and these kind of different things, they all fall back to, okay, goes back to it has to still pass the bar of does it violate the Constitution? And that freedom of speech one is really unique. And there's a ton of case law. So this is, again, why you need to consult an attorney and get them involved, because a lot of times they might say, hey, look, sorry, freedom of speech. Now, that doesn't mean, though, that an attorney won't write a cease and desist letter. The cease and desist is kind of like it's the entry level, right? That's like the first legal step one would take, correct?
Yeah. Yeah, it's like saying, hey, let's just stop doing this. It's like one step more formal than a conversation. I could come talk to you, Dan, but I don't like you, so I don't want to talk to you, which is false. I love you. Or I can just send you a letter that says, hey, Dan, stop talking about me. And everything's going to be okay. You stop? Cool. Everything's fine. We're just going to walk away.
What's the risk of sending a cease and desist then?
I don't know that there's a whole lot of risk. You could, if you try to write a cease and desist letter on your own, you could probably throw yourself into a potential issue. Not necessarily defamation, again, because I'm just sending it to you and I'm just saying it to you. But I think one of the sort of counters, like you can say, well, defamation, except if it's not true, or if it is true, but if it involves especially if it involves criminal claims or, I think if I remember back to law school, maybe there was things like, people's sexual disorientation or, whatever it is. Like if it's super bad, that just rises to a whole nother level of treble damages and things like that. So you do have to be careful that you can't just I can't just send you a letter that, makes all of these just blanket unfettered claims about you as a person and your criminal aspect, whatever it is. But as long as it's not, if you get an attorney and an attorney knows what to write in these things and they send a cease and desist letter, really your only risk there is just either one, the money you pay an attorney to do it, and two, the person doesn't stop. But
yeah, it may make them double down.
Right.
Yeah,
it can backfire.
That's them calling your bluff and going, right. Try me. I'm going to say it louder.
Right. That could have a backfire, but it's not like you can get sued because you sent somebody a cease and desist letter, right. Generally speaking.
Could someone then send you a cease and desist for harassment and kind of argue that you're using the legal system inappropriately, trying to threaten someone for exercising their First Amendment rights?
Yeah. Yeah, you could get a pissing match over cease and desist letters.
Attorneys love that. They just have a good time typing them up, and they just cash in those checks. If you've never paid for an attorney, they're not cheap, guys, and they charge by the 15-minute time frame. So,
not us. We do everything flat rates.
I know. You guys are great, but most attorneys are 15 minutes, 15 minutes. And I worked for 2 minutes. That equals 15 minutes. They always round up way different than they did in math class. And respect where respect is due.
And I'll touch briefly there, Dan, on harassment, because you kind of threw around that legal term a little bit. Harassment is even harder than defamation. Harassment is there is civil harassment. It's typically a criminal thing. And
that's my world.
Yep, you know this as a police officer. Somebody calling me a couple of times and saying bad things to me is not harassment. If I'm getting like 10 phone calls a day for a week at a time, yeah, now I've probably got something that rises to a level of harassment. But people love to throw around that word of like, well, they're harassing me. And I'm like, well, what did they do? And they're like, well, they sent me a couple of emails. I'm like, cool. I get that that's not nice. It doesn't make you feel good, but that doesn't rise to a level of harassment. And again, Dan, I won't take your thunder on that because that's your realm and you can talk more about that from your old job and perspective than I can, but it's really got to jump up there.
Yeah, it's super hard. There's two different kinds of harassment in Oregon. There's like physical harassment, which is offensive physical contact. And then there's telephonic harassment, electronic harassment, all those things. And those telephonic harassments and electronic harassments and things are so hard to prove. It has to be repeated and ongoing unwanted contacts that the person knows is unwanted. So like, even if someone called you 100 times, if you didn't like say almost specifically, do not contact me again, any future contact will be considered harassment, and then document all those additional contact. Like it was just so obnoxiously laborious. And even then it would rarely get charged and rarely go to trial or have someone get convicted on it. It was just super duper hard to do. So it's few and far between. Yeah. So this is obviously we could just like hypothesize and talk about cease and desist and demand letters a lot. Correct me if I'm wrong, but the big things are if you think you have something going on where you need some help, to send someone a letter, to try and get someone to stop defaming you, or you just need advice on does this rise to this level, contact Matt, contact an attorney, get in touch with somebody, speak to a professional. If you receive a letter claiming something, don't respond immediately, contact Matt or an attorney.
Yeah, that's all fair. Yeah.
And I will just say, like I kind of alluded to, and I'm not going to get into super deep detail, but I got a cease and desist letter claiming defamation for some things that I said about a company's product. And it was my personal opinion. And I was like, hey, these are my opinions. I actually talk, you guys all know, you listen to the podcast. I call balls and strikes. If you do a great job at something, I'm going to say great job. If you do a not great job at something, I'm going to say, hey, think of this. And it came up and I read the information and I started drafting up my email response. And I was like, well, this is my personal opinion, this First Amendment, blah, 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 blah. I did the listening to my own advice, the voice in your back of your head that's like, stop, stop, stop. And I was like, okay, I wrote it. And for me, that's therapeutic, right? I like write it all out and I don't hit send. And if I really need to send it, I just send it to myself or Tori or somebody like that. I actually did send it to my attorney. I said, because I have a local attorney and then I use Matt for a lot of stuff as well. And so I sent it to my local attorney who's done some other things for me in the past. And I said, hey, I might need your services on this one. And then I obviously called Matt and had a conversation with him. Arguably, it's good not to respond, especially in that heated moment.
Yeah. And that's another advantage of using attorneys is, we are supposed to be neutral, unbiased, unemotional third parties. And so I know what you want to say. I understand how you're feeling. It's not going to get us anywhere if we go out guns a-blazing with all of these emotions. Let me attack it with black and white legal stuff to send over to somebody to take to an attorney so we can have attorney conversations and not worrying about like all of the emotion that gets behind it.
Not only an attorney, but a counselor.
Which seems to be another name for an attorney, too. So
I hear what you're saying. I understand why you're frustrated. However, any parting words, anything else to kind of wrap this up as we've talked about cease and desist, demand letters, anything for people to keep in mind?
No, I don't think so. I think we've hit the nail on the head a number of times. We're good.
Okay. And if people need your help with one of these things, they reach out to you through your website?
That's the easiest way, is just to go to jimlawyers.com. There's calls to action on there. You can schedule a 45-minute consultation. My email's on there if you want to get a hold of me via email. My cell phone's on there, although admittedly, if you try cold calling me, it's very difficult to get through just because I'm talking to gym owners all the time, all day, every day. So it's best to just do the call to action, get 45 minutes on my calendar, or shoot me an email if something feels a little bit more urgent than that. And we can talk from there.
Yeah. And I'll shamelessly plug Matt again and just say the delivery, the product delivery is fantastic. The customer service is great, but the best thing, and I kind of joked about it, but that everything is flat rate. So you know exactly what you're getting into. Hey, it's going to cost X amount of dollars to get this thing done, and you're good. I know you bill by the hour, and it's not even necessarily you working on it. It's your associate working on it, but I'm paying your rent. Like, you just know what you're getting. It's really clear. And I'm not talking badly about any other attorney, but just from a gym owner's perspective, with cheer gyms where we don't have a legal budget, generally speaking, and we don't have the need to have an attorney on retainer, it's a really great service for us. So make sure you reach out. Thank you, everyone, for listening. And with that, we'll catch you on the next episode.
See you, Dan.
See ya.